know that this fight continues because of all of you, and I get more strength from you than you possibly could get from me. And one of the worst losses, other than the physical losses of this nightmare, has been the loss of my reputation. And I feel like I have it back in spades because of the people in this room that embrace me despite hearing horrible things, untrue and embarrassing things about me that were never meant to see the light of day. And you don't care. And I love all of you and your generosity, and the Roccos, Nick and Jenna. Who spearhead the fundraising, and the generosity of my friends that I've known forever. And I love everyone in this room, and you keep me going, and I feel like this is my purpose, and it's more important than anything I did in my prior life. And I'm not the first person this has happened to. It happens to people in this state, in these counties in this state every day, and they are not fortunate enough to even post bail in many cases, or to have the legal help, or the media help that I have, or the family possibly that I have. So although I've been very unlucky, I feel like the most fortunate person in the world, and that is in no small part due to the people in this room. And I thank you, and I love you for it. And I will be as strong for as long as it takes. We're seeing this through to the absolute end. And
so I have to be really reserved in what I say, but I have a dark feeling about this, and that'll be a bad day for the Massachusetts judicial system if that happens. Maybe I'm wrong. I think the judge should err on the side of letting it all in, because if she does not allow it in, and if in the horrible potentiality that Ms. Reed is convicted, this is an issue for appeal.
You know, there were 2 Daubert hearings held for Dr. Marie Russell, who is I don't know if she's triple board certified, double board certified doctor, medical doctor with over 30 years experience. 2 Daubert hearings were held. The last one was held last Tuesday.
Dr. Russell spent an entire day going through her extensive, varied, and I found very interesting resume, because not only had she trained as a police officer, she's also a treating physician. She had also worked as a coroner. She had also worked in state prison and in county facilities. She's dealt with people who, in the treatment of police dog bites and non-police civilian dog bites in the busiest ER, I think one of the busiest probably in the country, but for sure one of the busiest in the state of California at County USC.
So again, less than a week when this finished, she's got her order out. Respect.
So in a shocking surprise, we have a decision within less than 1 week from Dr. Russell's second Daubert hearing. So that's the biggest surprise of all, I think.
Her testimony consistently has been that those injuries are more consistent with a dog than they are with a car. The court is going to allow Dr. Russell to testify, but definitely put a bit of an asterisk in her ruling, saying that it's noted that Dr. Russell did not compare the dentition of the dog in question to the injuries.
He is really working on trying to get rid of all of the defense's expert witnesses one by one. He's trying to pick them off, but is that really what he's doing? Or is he just, in my view, doing the equivalent of conducting depositions of these people?
We're going to get the judge's decision right here in the first paragraph, but the rest of the order is what makes me raise an eyebrow a little bit as to the totally unnecessary commentary that the judge has in her order, and what both sides can kind of take from this as they prepare for this expert witness to testify in trial number 2.
Dr. Russell never testified that a specific dog caused the injury to John O'Keefe, just that it was a dog, not a car. And so the court bringing that up was interesting to me.
Remember, when we are discussing cross-examination, and something that I've always talked about on this channel, whether it's the Karen Reed case or any other case, is that a common line of cross-examination, all trial lawyers know this, a common line of cross-examination is always to show what the expert did not have. You always try to show that so you can argue to the jury, look, I like this expert. He's a great guy. Maybe he's a real good expert, but he just simply didn't have all the information in this case.
But I think Dr. Russell did not articulate well, and Dr. Russell articulated lots well, did not articulate this well, in my opinion, was that the other information doesn't really change what those injuries visually look like. It doesn't change. You can give me all the information in the world, but visually, those injuries are in the pattern, she said, of a dog attack.
Mr. Brennan says, well, she's not a certified orthopedic physician. I would think that the jurors are smart enough to say, well, she didn't say she was. Dr. Russell is not an accident reconstructionist. I think that jurors are smart enough to say, that's not why they put her on the stand. That's just not it. So that's why I think that the issue that was raised in the Daubert hearing for Marie Russell was an issue of credibility and not an issue of admissibility. So in my view, and I've said it before, this was 2 days of wasted judicial resources.
So sure, you can give me more information, but when I look at it in an ER, I don't have all that information. When I look at it to treat it and to triage, I don't have all that information. When I recognize the pattern of injury, I don't have all that information, and I don't need it. You know why? Because I look at that and went, that came from a dog.
I appreciate this out of Judge Cannoni. This is the correct and proper question, not whether she's right, not whether she's 100% correct, but does her testimony meet the requirements of Daubert?
In a civil case, we civil attorneys do depositions. You file a claim, then the insurance companies with unlimited funds, start deposing everybody in the world, your client, your client's family. What did they observe? What did they see? Everybody in the world. And why are they doing that? Not just to run up the bill, although that is part of the reason.
Her experience went on for a day, and then there was a half a day of cross-examination, a little bit more from the special prosecutor getting to, and this is the special prosecutor's point, getting to, so you just looked at it, that's the scientific methodology here. You just look at it. You don't know if that bite comes from a canine, if this comes from that, if that comes from that. And she's like, I have treated thousands of dog bites. That scratch pattern didn't come from a Lexus. That didn't come from a motor vehicle collision. That's not road rash.
Did anybody really think she was going to overrule herself, having already admitted her to be able to testify as an expert in trial number 1? That would have been just whack if she all of a sudden decided she was wrong the first time. And now Dr. Russell can't testify because she's not qualified. Because if there's one thing that we know about Justice Cannoni, is she does not like to admit that she was wrong.
Although a close question, the court will deny the Commonwealth's motion. So first off, whether something is a close question or not doesn't really matter when you make your decision. It's denied, meaning she can testify. Now, what this does open the door for, and what some lawyers will take as a suggestion for this, is to try again. Judge, will you reconsider this? Or at the time she comes to trial, Judge, you said it was a close call or a close question in your order. Can we strike this part of her testimony or try to strike her again because of X, Y, and Z?
Part of the reason is because they are now locking in the testimony of all of those people who may not have prepared themselves adequately for the actual trial, so that when they come to trial, now their testimony is locked in on paper under oath. And if they deviate from that at all, they are impeached, or at the very least cross-examined. So in my mind, that is what Mr. Brennan is doing in this case.
Additionally, if this was denying a defendant's motion and a judge called it a close call, you better believe this one would be highlighted on the docket as something to use for appeal. Even the trial court judge admitted this was a close call and the judge got it wrong, appellate court.
Accordingly, they said the court finds that Dr. Russell's testimony satisfies the 5 foundational elements and therefore will allow Dr. Russell to testify as to whether the abrasions on John O'Keefe's right arm were caused by a dog. Period. The fact that there's another paragraph concerns me because that's period. That's the end of the ruling. That's it. That's it. That's the end. These are why the foundational elements have been met. This is why we're allowing it, period. Why are we still talking? Emily, you're the one talking about snare snaps from Carter and how you can identify them by like vibes. I know. The hypocrisy.
So this is just the end of the order where she starts talking about what she's seen on cross-examination, which people are talking about. Why is she doing this? Okay, it doesn't matter.
This last paragraph, which is the shade, I think, thrown at Karen Reed's team as a whole, almost, not just Dr. Russell, but also some props and tips given to the Commonwealth as to here's what I, as a jurist and a lawyer and a judge, think are some really good points you made. Judges very rarely list it out in their order, especially when they're allowing that expert to testify. But this judge did that.
In so ruling, why are you still talking, Your Honor? Stop typing. Just this is the part you leave in the drafts. Leave it in the drafts. Damn it.
And if you don't have all the information, well, then how can we trust your expert opinion? It's not based on all the evidence. And we've explained this in our other videos about why that argument really is not a good one. And the reason is that when you're talking about evidence that the expert did not have, the question is not how much evidence he did not have, because you can list a million things. You can list all types of irrelevant material that the expert did not have.
It's like, okay, but that's not something that you're going to strike an expert for. So why are you mentioning it here? I have had judges say the other side brought up a lot of fodder for cross. They'll have the opportunity to cross-examine her. A lot of that goes to the weight, not the admissibility, not whether or not I'm going to allow them to testify, but how credible or reliable is their testimony. And they'll be allowed to do that on cross, something vague like that. But a specific list is abnormal in my experience.
Order. For the foregoing reasons, the Commonwealth's motion to exclude the testimony of Dr. Marie Russell is denied. XOXO.
So I would expect that Brennan realizes that even though he lost this, the judge is basically tipping a cap to him. There's no real other way to say that. And she's showing him basically that even though you lost, I get your arguments, I get where you're coming from. So go ahead and keep fighting, Tiger, is what it feels like a little bit to me. Shade toward the defense, a tip of the cap to the prosecution, like a job well done, as if lawyers need that when they lose motion. It's like, big deal. We realize we make our arguments, we win some, we lose some. But for the judge to go out of her way to highlight and list out points that we made during cross-examination to tell us that's some good stuff for cross during trial, but that you're going to let him in, to me, was done purposefully by Judge Cannone.
And it just seems, again, that the Commonwealth just wants to depose these witnesses just to lock in their testimony. It makes no sense that they're, wasting 2 whole days on these hearings.
It's like those math professors who could explain like quantum physics to you. And you're like, look, I just need to understand algebra 1. I just need you to explain it, please.